Is he still there? Are you done?
Such a sweet. Entrance to confidence. It just pops up what we see. You can speak language, but you can't see. But maybe it's the way you This morning.
Also,
Yeah.
All rise. District Court of Appeal of the State of Florida and for the Second District is now in session. The Honorable Morris Silverman, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. You may be seated.
Good morning, everyone. Welcome to this session of the court. We are joined by Judge Morris and Judge Sweet. We have several cases on the docket, and we will take them in the order that they are listed. For the second and third cases involving the City of Tampa and Liberty Hospitality, I don't know if the parties have discussed how they wish to present the arguments, but I'm going to be asking whether they will be consolidated into one argument, since the arguments seem to overlap quite well, but we'll deal with that later. But if you hadn't talked about it, among the council, and you might want to chat how you want to present that. Other than that, we are ready for the first case, which I need to put my glasses on. Kessler versus Progressive. One reminder for counsel for the appellants in all the cases, if you wish to reserve up to 5 minutes of rebuttal time, let me know, and I will let you know when you get to that point in your argument. Remember, we are live streaming, so speak into the microphone, please. And with that, Mr. Gunn, we're ready.
Good morning, and may it please the court. Lee Gunn for Bridget Kessler, the petitioner in this interlocutory appeal, seeking that you quash a trial court order that invaded both the work product and attorney-client privileges of the claimant bringing a bad faith action. Briefly and factually, this arises out of a car crash on March 3, 2018. Progressive affords $200,000 in uninsured motorist coverage. 19 months after the loss, Ms. Kessler's counsel below filed a civil remedy notice, thereby triggering the 60-day cure period that statute affords. This being a first-party bad faith case, that case is controlled exclusively by statute. There is no common law right, and never has been in Florida, for someone to bring a bad faith case for first-party misconduct. The CRN simply alleges the 1B1 of 624155, that is, the failure to settle the claim when Progressive could and should do so when acting fairly and honestly and with due regard for Ms. Kessler's interests. Now, it's undisputed that Progressive could have paid a $200,000 policy limit during that 60-day period to cure. It did not do so. Had Progressive chosen to pay during the cure period, it is undisputed that no claim of bad faith would or could exist. It is these facts, Your Honors, that conclusively establish Ms. Kessler's willingness to settle for purposes of meeting the could have settled under the statutory scheme.
One question.
Your Honor.
None of you mentioned in your briefs or petitions, opinions. Did you serve a proposal for settlement from
Out of time from when the violation was noticed, yes.
and Progressive when it expired?
Yes.
Under the law, had they accepted it? Would you have a right to bad faith?
Yes, you can preserve your bad faith case in a proposal for settlement that only brings the claim, Your Honor. So it's certainly once you, as you know, once you perfect the bad faith right, and here where we had both counts pending in the case, right, we had under the Friedman authority, the court allowed. So if you have the entire action being both bad faith and you can serve a proposal for settlement, the terms of which are directed to only count one, the count, or to the entire case. So you could have served and preserved.
So they took Ms. Catlich's deposition, right?
Yes.
And they asked her about her evaluation. She did talk about tangibles, intangibles, medicals, lost wages, future medicals. They even asked her what she thought it was worth, and she testified that it was worth more than $200,000. But it wasn't until they asked her, was Ms. Kessler willing to settle for less, that she invoked attorney-client privilege. Is there a Florida state case that allows a trial court to compel any attorney, whether it be for Progressive or for a plaintiff, to testify about the oral communications with their client about whether or not to take it on?
I'm unaware of any such case. Indeed, Genovese would provide support for the proposition that a carrier's counsel is protected from my asking Progressive's lawyers, well, what did you think the case was worth? Did you advise Progressive to go ahead and cure? I can't get into any of their communications under Genovese, which was a clarification of the Ruiz holding, which said that the insurer's file is fair game, but then not so far as to say the attorney-client privilege is also fair game. Genovese said no.
That's her deposition. Would you accept less?
I'm sorry, Your Honor?
They asked Ms. Kessler in her deposition, would you accept less than policy?
I honestly don't know if that's part of the record.
It's not in the record.
Yeah,
It's very sparse.
right.
Progressive doesn't give us much. well, it just tells us the case is not worth anything, and the other, they gave the old, that was the old times, only 3 times medical offer, and went up to $75,000. But yet argue, she didn't need surgery, she didn't want surgery, nobody wants surgery. But, so, tell me, on what basis, because the trial court ordered an in-camera inspection of the privileged documents, which means under 1.28 OC4, she can restrict disclosure or not. But yet she granted the second deposition of Ms. Catlett with no guardrails or limitations. It's simply granted it. What was the legal basis for that?
I believe that the court must have conflated the third-party principles of the willingness to settle in order to prove that there could have gotten a release if you would have sought one. All I know is the court on argument of progressive accepted the proposition that because willingness to settle is an issue, then that means they're allowed to get into any willingness to settle at all that was injected in this case, including by injection waiver, the attorney-client privilege. And I agree with the court, and we specifically briefed the fact that the in-camera is not right for us to talk about the documents because it hasn't been. But to the court's point, when you say to the witness, you have to answer all these questions about inferentially what's in these documents. That's why we felt the petition was necessary and appropriate under jurisdictional grounds and practical grounds as well, Your Honors. So,
But it isn't, I mean, I don't want to make your argument for you, but one of the things that strikes me is if a party wants to settle a case, it makes an offer, and the other party either accepts it or rejects it. And Progressive made at least, 2 offers, if I remember, in this case. And your client didn't accept it. So then the question becomes, well, would she have accepted more? And that might be a negotiation strategy, offer more, go back and forth. And even if your client, through counsel, chooses not to engage in settlement discussions, doesn't the ultimate issue turn on, did your client cooperate with discovery requests? That would be a defense to bad faith, that there wasn't satisfactory cooperation, information was withheld, and so forth. So I'm sort of struggling with this idea that, at least under the law that applies to this case, that there's been a showing of necessity and appropriateness to get information. But neither party seem to really get into this idea of, well, what defenses would there be regardless of any information that's disclosed in violation of attorney-client or work product?
right, and we tried to brief that. I'm sorry if we didn't do it well, but the substantial need to overcome work product, which is completely inapplicable to attorney-client. But does Progressive have a substantial need? And that also, is there any obligation on Ms. Kessler as a claimant to, quote, cooperatively compromise her policy limit and take less than she believes by her CRN's submission she's due? A claimant merely says to the carrier, I've been hurt, I have coverage, I am making a claim. The carrier then must investigate that claim. It must evaluate that claim, and it must pay that claim.
There's a duty to cooperate.
And there's a duty to cooperate on the part of the insured, and can give rise, if you materially don't cooperate, to a prejudice forfeiture of coverage defense to a carrier. Okay, so which is a non-issue that was never asserted by Progressive. But yes, the tools in a toolbox that Progressive owns through its policy language include such things as an examination of person without a lawsuit, right? An examination under oath without a lawsuit. They have the discovery tools that parallel much of litigation tools to investigate and evaluate a claim. The issue in the court is simply on the merits, is simply this. Knowing that it could have paid under the Talat and Vest theories of what is a cure, right? Cure is payment. Okay, it's not an offer, it's not a negotiation, it's you pay a benefit that's due. Here it's a benefit. Vest and Talat say if the benefit is paid, you've cured. If you cure, there's no statutory bad faith case. That cause of action doesn't exist at all. If you don't cure and you don't use that 60 days to say, maybe this is the claim we should have paid, and you choose to stand behind your non-payment decision, then you risk a jury will later find that that non-payment decision was, quote, bad faith in the sense you could, all you had to do is write the check. And you,
That goes back to my question.
yes,
Which is even when that notice is issued, if they don't want to accept it because they don't believe the value of the case warrants it, that becomes a defense to the bad faith claim.
that goes to the, what I would argue to be the sole issue that we try in this case. Should Progressive, acting fairly and honestly and with due regard and diligence and care, have determined to make a payment during the safe harbor of cure, thereby meeting its obligations under the policy as well as avoiding any bad faith remedy vesting? That is the core issue. And the Progressive is entitled to point out what it did have, and I'm entitled to point out what you should have had. And if there's non-cooperation, if there's purposefulness and avoidance, then certainly they can get into, they being Progressive, can get into, well, we didn't know and couldn't know, and therefore we shouldn't have paid. Those are all go to the central core issue of a UM bad faith case. Did the UM care do its job to investigate, evaluate, and pay? Did it attempt to get records that could not be gotten? Well, of course, that's a
Mr.
defense.
President, you still have here just over 8 minutes. Do you want to reserve any time for rebuttal?
I'm sorry if I didn't say I had 5 minutes. I apologize.
Didn't write it down.
I apologize. I'm sure it's an omission. Thank you. So 8 minutes, meaning I have up to 20.
You have 3 minutes when you hit your 5.
I appreciate that clarity. So yes, that is the central issue. So if we look at what does Progressive need to know, what's the substantial need? It's not what's in the mind of the claimant or Ms. Catlett. It is what did we know and what should we know and what could we, with exercising diligence and care, know? And did we, with that knowledge, act fairly and honestly and make a fair payment? That's the UM case.
Progressive's main argument is lack of records, which can be a problem, but also a late undisclosed surgery. And they put in their appendix that she had testified she didn't want surgery. And she had surgery late in June or something like that, and then they tendered limits. Could they get me opposed, Ms. Kessler, and say, why did you wait to have surgery?
Your Honor, I think this case gives this court, and I would submit claimants generally, the opportunity to provide overall guidance to what is the issue in a first party bad faith case and what's the relevant scope of discovery and information needed by an insurer. It certainly isn't to invade an attorney-client's communications with the claimant about anything that has to do with the claim. So now we go to the next layer, which is, well, what about the attorney's opinion work product or fact work product, or what is or isn't in the attorney's file? Let me lay that out in practical terms. If an attorney is going to express an opinion, and you could express it, I don't want to invite the argument, they could say, well, they've opened the door. By letting Ms. Catchler testify to as much as she did about her opinion of the value of the case, perhaps that means that her work product is now discoverable, right? I didn't see that in the papers, but I'm going to be upfront with the court.
Well, there's a difference between fact work product and opinion work product. Once it got to her opinions in terms of the way she related and what opinions she related to Ms. Kessler, she invoked the privilege. But when it came down to her experience as a trial lawyer, as to how she evaluated the case, it seems to me that she was candid.
I don't think that anyone has accused Ms. Cashledge of lack of candor. I think what we're trying to establish through this petition is the ground rules for trial judges who I argue this in front of. In fact, with opposing counsel's firm, I was in front of Judge Barber yesterday on willingness to settle in a UM case is an issue. So I think that if willingness to settle is a non-issue, that takes care of the attorney-client invasion issue, right? Because there's nothing here about a willingness and, did you advise the client that she should settle and why didn't you take these other numbers? And none of that's relevant. On the issue of fact work product, it is certainly arguable that they had a substantial need to show that the attorney had information in her file or his file that was not shared. Not why wasn't it shared, the mental reasons for that, but just, hey, you had this record and you didn't give it to us. And that was material, right? And with that material, and then I argue, what you should have had that. If you didn't get a med auth, you should have gotten a med auth. You should have pursued the medical authorization. You never rely on a case law that you can't just take the plaintiff's word for anything when you evaluate a claim. So, you go get your own records, and if you didn't get a med auth, you insist on it. And if the med auth doesn't come, you reserve your coverage rights. There's many tools and many ways this gets handled without invading an attorney's fact work product, and certainly the attorney's opinion work product.
Judge Sleep, give me just a moment. You're at the 5 minutes. We'll let Judge Sleep ask his question, and then you can respond to it briefly. And if you want to reserve the 5, you'll need to sit down after you answer that.
What's your response to Progressive's assertion that they're finding out that the Ruth firm contacted you during litigation is somehow discoverable?
That's just completely outside the scope of discovery, non-discoverable, and it's a quid pro quo for Genevieve, Your Honor.
Good morning. May it please the court. My name is Carlos Gomez and I represent Progressive. Your Honors, this court should deny the petition and affirm the trial court's discovery order because there is no departure from the essential requirements of the law, and neither do we believe that the plaintiff has established irreparable harm here. Since irreparable harm is a jurisdictional element, I think the court should probably analyze that
Well,
first.
just ask a question about that. I mean, if you're basically allowed to, to conduct a deposition and inquire into the attorney-client privilege, that's a pretty sacrosanct thing. So how would you elaborate on the lack of irreparable harm? Because that seems irreparably harmful to me.
Yeah, Your Honor, and I think the issue here is we're dealing with a very specific discovery order that posed very specific discovery or deposition questions to the attorney. Part of the argument with the trial court judge was that the questions that were posed to Mrs. Catledge, we don't agree that they were actually seeking attorney-client privilege communications. And the request for relief during the hearing was, we want to ask Ms. Catledge these specific questions. I don't agree that the trial court just wholeheartedly waived or issued some sort of blanket waiver or allowed Progressive to engage in any and all communications or ask questions about any and all communications related to attorney-client privilege.
To me, the trial court order doesn't give any narrowing of what can occur at the deposition, correct?
I do agree with that, Your Honor.
So isn't that problematic?
I think the trial court's order necessarily has to be limited to the specific relief and arguments that were present or presented to the trial court judge.
Does the record tell us who prepared this order for the court, or the court prepared on her own?
I think we prepared the order, counsel for plaintiff approved it, court executed it.
I'm not sure if it was you below, but counsel below for Progressive spent the bulk of their time talking about the work product paper discovery.
Yes, sir.
And then you transition, it's only a couple of pages. The same concepts, the concepts you argued about work to C4, which is undue hardship and everything else, which the Supreme Court made very crystal clear, doesn't apply to attorney-client privilege in Genevieve. That's one. But you argued, or someone argued below, the same concepts as to the work product required in deposition. And you said, we were questioning our own basis for their position that the claim was worth more than $200,000. We've already answered. And then we believe we are entitled to know why they thought that. The rule 1.280 clearly says you can't give the attorney's thoughts and conclusions and impressions. So you argued, you tried to bootstrap 1.280 into the attorney-client privilege when you know full well the Supreme Court said no. The Supreme Court even says, even if that disclosure supports your defense, the attorney-client privilege prevents it, prohibits it. And so the court granted your motion for a second deposition, because you cite a federal case, Wilkins, some other case, written That's the first deposition of the attorney. This is the second deposition of an attorney who told you, here's from A to Z, how I evaluated the case factually. But then you ask, was your client willing to take less? Well, how is a client to know that unless the attorney advises them? Tell me that.
Well, I think with regard to whether the client was willing to take less, Judge, I think that is a simple yes or no
But
response.
that's a conversation between Ms. Kessler and Ms. Catlidge, is it not?
Well, it would be if we asked her what the why and what those communications were.
Okay, so Mr. Lenagro was the attorney below?
I'm sorry,
Was Mr. Lenagro the attorney below in the Dion case?
Mrs. Catlett was
He was the defense attorney.
the defense attorney. I'm not sure.
Okay, let's just say it was Mr. Schmidt.
Yeah.
So based on your argument, we accept your argument, we deny this. Then Mr. Gunsberg can go take the deposition of the defense attorney and ask him, how did you evaluate this case and what offers did you tell him to make? And what was the ultimate offer to make? And what did you tell him about how to handle this case? You agree?
If Mr. Gunn attempts to take the deposition of the underlying attorney that defended,
Yes.
yeah, I think that they are allowed to obtain that sort of information because there is,
Okay.
according to Allstate versus Ruiz, Your Honor.
Yes, you said.
Well, if you're,
Simply puts a one-perfect exception to the claims filed. The Supreme Court had the right Genovese to say, oh, wait a minute, attorney-client privilege still applies. Two different cases, two different issues.
sure, yeah, so maybe, let me clarify.
Based on Genovese, could they take the defense attorney's deposition and ask him, what occurred between you and the adjuster? What did your advisor offer? What did y'all evaluate the case at?
No, based on Genovese, I don't think that they can ask those questions.
Why are you?
And so going back to the specific questions that were asked of Mrs. Catlidge, those questions were 4 questions. During your handling of the claim, was Ms. Kessler willing to negotiate for less than the policy limits? Was Ms. Kessler?
Those two talking and having a private discussion because Ms. Kessler is not sophisticated in personal injury litigation. She has to rely on Ms. Catlidge to say this isn't enough because your injuries are X, Y, and Z. Plus, Ms. Catlidge was candid in her deposition and said, you guys undervalued this case because it's a significant injury. She's been through a lot.
Yeah, I think attorney-client privilege, because it is a strong privilege, Judge, it has to be interpreted narrowly. It is the privileged communications regarding the rendition of legal services or the rendition of legal advice. We're not asking Mrs. Catlidge to disclose those specific communications that she had with Mrs. Kessler. We're asking her a simple yes or no question. Was she willing to settle for less or no? Yes or no? Was Ms. Kessler ever willing to accept, was Ms. Kessler willing to settle for the $200,000 policy limits? Yes or no? At what point was Ms. Kessler no longer willing to settle for the $200,000 policy limits? Give me a date. But we're not asking her, explain to me what communications you had with Ms. Kessler related to those decisions.
Well, the record's pretty clear that Ms. Kessler was willing to accept $200,000 in limits as of December 4th, 2018. And they never, ever wavered.
I understand that that would be the plaintiff's position,
And
which means,
the record shows.
well, the record,
You offered $43,000 3 times meds, and then you found some more records and you offered $75,000. But they stayed at $200,000.
the record shows that Mrs. Kessler filed a CRN, which she has to do in order to perfect a statutory cause of action for bad faith under 624-155. I think that goes beyond the pale of establishing that she was willing to settle. I think there's a slight difference.
Because you think the case is worth less. Beyond the pale, the law is clear that a plaintiff or a claimant can file a CRN even before you determine liability and damages. They are not required by law to make any kind of counteroffer to you. They can file a CRN.
It would be no different, Judge, if even in a third-party context, the plaintiff sends a demand and says that I'm willing to sign a release on behalf of just to release the insured if you immediately tender the policy limits right now, but I'm not going to provide you the necessary medical records that you need to substantiate a tender of the full policy limits. I'm not.
That's a different issue. And that goes to the question of bad faith and whether you have a defense to bad faith. Right?
Well,
You're not entitled to say, or at least this case is addressing, you're not entitled to say, we have all the records, we don't think the case is worth 40,000. What do you think the case is worth? I mean, is that something that, is there any authority that says you can do that?
Well, Judge, I think it goes to the issue of willingness to settle, which Mr. Lee does not dispute that they have to establish.
To settle demonstrated by you make an offer and it's accepted or rejected. Maybe you make another offer and it's accepted or rejected. You might make 10 offers and they're either accepted, one of them is either accepted or rejected. And it seems to me if you're asking a plaintiff, an individual plaintiff, basically, what is your case worth? Doesn't that necessarily involve an evaluation by the attorney? That's why people go to lawyers?
Yes, I do agree with
You're
that.
not a lawyer, right?
Ms. Kessler's not aware.
So are you suggesting that any plaintiff has an obligation without the advice of counsel, without the assistance of counsel, without the input of counsel, to know what their case is worth?
I think that I don't know about the specific, it depends on what the plaintiff would say. The plaintiff might say, well, I relied on my attorney, in which case then we would ask the attorney, okay, then what do you believe the case was worth?
Well, let's say you take her deposition again. We're talking about Mr. Catlers, the attorney. Because you seem to argue here that if Mr. Kessler said, you know, I'm broke and I really need to take some kind of money, can you just try to get less? And Mr. Catlett says, you have a neck injury that may or may not need surgery. You have these issues, and based on my experience, you're going to have ongoing problems, and I would advise you against it. And if she accepts that advice, what you're saying here is that conversation is discovered.
No,
She relies on her attorney, well, even if she's willing to because of some personal reason, but her attorney, who she's relying on, says, I would advise against it because of my experience, your injuries, and what I've known in the past, and you're going to encounter. It's not enough. And she said, okay, I agree. You're saying that conversation is discoverable in a bad faith case.
Well, it really depends. I think with regard to the specific questions that were posed, I think we're entitled to do attorney-client privilege.
So in that scenario, let's say if she was willing, but the attorney told her not to based on her experience with injuries like this, because she ultimately had a fusion of her neck, which is not a laminectomy, discectomy. This is a major deal. Okay? So what you're saying is even she was willing to take less than 200, and they had that conversation. And Ms. Catlett, based on her experience as an attorney, advised against it, and she agreed and said, okay, I won't. That's discoverable.
I would argue yes, because it goes to the direct issue, the essential claim that the plaintiff has to establish, which is code himself.
The defense attorney for the UN carrier, Progressive says, you need to sell this thing for 200. The adjuster says no. Mr. Gunn will take that deposition and ask about that conversation. Is that discoverable?
Arguably. If our defense is we're placing the direct issue on our defense, saying that we couldn't have some.
Defense attorney in this case, that's an exception under the law. If you're blaming defense attorney, then the attorney-client privilege is waived, but you're not in this case. So what I'm saying is that the defense attorney for Progressive told the adjuster, you better settle this case for 200 for policy limits, and she said, no, I'm not going. Is that discoverable in a deposition?
I don't think so, Judge.
Okay, then why is that?
Because I think it's the plaintiff who places it at issue. She has the burden to prove.
It's an issue, and what the Supreme Court says is the focus on a bad faith case is on the conduct of the insurer. You misread Berry. Berry is a post-trial appeal of a denial of a motion for new trial. In Berry, the expert testified and the plaintiff did not object. The expert testified that they manufactured a bad faith case. The fourth DCA said there's no error. You invited the error because you didn't object. And then the fourth DCA reminded us that the focus is on the carrier, but the motives of the claimant and their attorney is relevant. That has nothing to do with the pretrial discovery deposition of the claimant's attorney.
Judge, well, the case law also says that while the focus is on the insurance company or the conduct of the insurance company, the case law also says that the standard is the totality of the circumstances.
Okay.
And so what the vast majority of the cases, granted they are in federal court because we have a lot of federal litigation on these issues, say that based on the totality of the circumstances, the conduct and the motives of the underlying claimant's attorney is relevant. And based on that, the insurance company has a substantial need to invade the work product material of the underlying attorney. In the same way that an insurance company has to disclose their claim file material, because it's virtually the only source of evidence that.
But that's different, because the case law talks about the insurance company has a duty to properly, fairly evaluate the case. And it can do that with records. Maybe it can't do it because there's an absence of records or there's a failure to cooperate by the plaintiff. But the plaintiff's evaluation of the case doesn't seem to me to make a big difference to the insurance company, except, well, maybe we can sell it for less than we think they really will take, and we can do better. Don't you avoid that by making offers in what you believe are reasonably defensible amounts to settle the case?
But with regard to that specific issue, Judge, I think it could go to the credibility of the plaintiff's attorney who's going to come in at trial and testify that Progressive should have tendered the full policy limits. And if we have evidence from her file suggesting that she didn't even think that her own claim was worth the $200,000 limits when she sent the CRN, then I think we're entitled to that discovery.
It's different motivations, one of which may be get the money as quick as possible, one of which may be changing motivation as to what settlement amounts if something happens. For example, she realizes she needs surgery. So the plaintiff's lawyer's evaluation and advice to the client seemed to me to fall squarely within the privilege and work product protections as to their own evaluation. I'm really struggling with this idea that we need to know if they would have accepted less, because if they might have accepted less at some point in time, then we didn't have to pay the full amount. And the reason I'm struggling with this so much is the amount might change as the case goes on. Once they do pre-suit negotiations and it fails, the case may have been worth $50,000 pre-suit. Now they got to get experts, they got to get records, they have to do things. So the number is shifting. A plaintiff, I don't think a plaintiff can make those kinds of decisions without the advice of counsel. That's where I'm struggling with this, because you haven't really addressed how's the plaintiff determine what a reasonable value of their case is.
Yeah, so I mean, there's two issues here, and perhaps we're maybe conflating between attorney-client privilege and work product. Our position with regard to the work product is that we are entitled to it, because in a bad faith action, there is a substantial need for us to assess the veracity of the plaintiff's claim and defend our position as an insurance company, which was that the claim was not worth the policy limits at the time that they made those demands. And perhaps even the plaintiff was preventing us from actually settling the claim because they failed to provide this necessary documentation.
You believe that the trial court was correct in doing the in-camera, and you may get that through that process, but you have to agree that Genovese clearly says that the undue hardship does not apply to attorney-client privilege information.
To attorney-client privilege, and I agree with that.
And even if it supports your defense, that's still not an exception to the attorney-client privilege under Genovese, correct?
Correct.
Okay.
Yeah.
So we're talking about the second deposition of an attorney.
Mhm.
No.
Okay, so establishing that with regard to the attorney-client privilege issue, Judge, again, we're talking about a very specific discovery order here. The document production hasn't been issued yet, and so I don't think that's right for the court's review at this point in time. The issue on appeal is the deposition testimony of Mrs. Catledge. The four questions that were posed, and I understand that Your Honor might disagree whether it necessarily requires the disclosure of attorney-client privilege. But when the plaintiff states that the issue is could have settled, and that we fundamentally establish or conclusively establish that we are willing to settle by the filing of a CRN, then I think we're entitled to assess the veracity of that claim and ask them about that. When you're telling me that you were willing to settle by sending a CRN, and then we ask you, well, at what point were you not willing to settle? Attorney-client privilege.
You have an independent statutory duty to evaluate the case and determine what it's worth without taking a plaintiff's deposition. You have that independent duty. What you're saying is you could not do this without hearing from the plaintiff as to whether she would take less. It doesn't make sense.
The deposition of the attorney was taken in this bad faith case.
I understand.
Right, and so maybe let's.
And you asked her if she was willing to take less, and then
Right.
you win the case.
Correct.
Right. That's what I'm getting at.
Right, and so going to the actual facts at issue in this
But it
case,
goes back to your duty. You have an independent duty. You can't take a plaintiff's deposition and figure out what it's worth. You have an independent duty to evaluate it and determine if benefits are owed or not.
I understand that, Judge, and nobody's disputing that. We understand that we have an independent duty.
That Bracet was unable to evaluate this UN without hearing from Ms. Kessler whether she was willing to take less.
No, we're saying that we are entitled to know whether Ms. Kessler was willing to take less, and at what point was she no longer willing to settle for the $200,000 policy limits, because we are entitled to defend our position, which is that we were trying to get records from you, you weren't providing them.
Show me in the just the whole record any indication that she was willing to take less, given the fact that they stayed at 200 since December of 2018, and they never wavered.
Well, the proposal for settlement is one example where she demanded less than the $200,000 policy limits. But I think probably more.
You didn't accept it, so.
Correct. And so I think if the plaintiff was willing to take less than the $200,000 policy limits, that's a simple yes or no question. I'm not saying that we perhaps will get any smoking gun out of that. I just don't think that that's a privileged question or demanding necessarily privileged communication.
At the end of your time, so take about 30 seconds, wrap up. And then
Yes, Your Honor.
Question, my brilliant.
Well, finish answering and then we'll start to go down.
Sure. So, Your Honors, just to wrap it up then, when it comes to work product privilege, Progressive is entitled to that material based on the law. I don't think that the plaintiff has cited any case law or any specific established principle of law that the court has violated in this case. Genovese stands for the proposition that an attorney-client privilege cannot be invaded with regard to the attorney, but when the plaintiff places the specific issue at issue, I think at that point it's waived and they're using it as a sword and shield and we're entitled to that information. Unless the court has any other questions.
He's out of time and it'll take too long to ask it, too long for him to answer, but I appreciate it.
Thank you, Your Honor.
Judge Lee asked all my questions.
Okay, appreciate it.
May it please the court. The fundamental flaw of Progressive's argument about the could is that in a statutory first party bad faith, they pay the money and the claim is settled. They could. And if they pay it in 60 days, there's no bad faith on a CRN. And if the case progresses, Judge Silverman, to a point where, oh, now it's really clear, as often happens, they have the surgery. Oh, well, now we'll pay the money. Without a notice of insurer violation proximal to, right, that surgical recommendation, that then they still don't pay, they don't cure. I can't talk about, well, now you know she's going to have surgery and then you didn't pay either. I'm confined under the law to the notice that I have given that at the time of the notice and during the cure, this claim was worth $200,000 and you should pay it. It is because of the mechanism of the civil remedy notice defining the scope of could and should that could is established as a matter of law conclusively by the ability under vest and lot for the carrier to write the appropriate fair value payment check. The case is over, the claim is over, and no bad faith remedy exists. All right. So it is for that reason that there's no willingness to settle in this case. But what about the legion of cases, including federal, which have applied willingness to settle concepts of discovery They're third-party cases or they're misapplying appropriate analysis. A third-party claimant's willingness to settle. Even if I would have handed the check to the claimants, remember, not the insured, the claimant, the third party, they weren't going to give me that release that I was bound to get for you. And that's why there's an excess judgment. So they in a third-party case must establish the stranger to the policy, the injured third-party claimant, would have settled. And they could have gotten a release. That's what makes this statutory structure so important to the scope of discovery. That distinction that if you wrote the check and you made the payment, Salat and Best tell us this is over. And the failure to do that is at your risk, insurer, that later in time, a jury will find that when you were given notice and a 60-day chance to get out of jail for free, you should have written that check. But you made a claim decision, advisedly or ill-advisedly, not to do that. And you can explain to the bad faith juror why you shouldn't have made the payment. I didn't know about this. I didn't get this. At that time, she didn't have a surgical recommendation. At that time, her medical bills were only $43. Please explain away why your conduct during the civil remedy cure was not to make the payment. But the issue below, the scope of discovery defined by that relevance, is simply this. Should Progressive, during that 60-day cure period, made a claim payment in good faith? And if it did that, they win their case. If they didn't do that. So then we look at the scope of discovery. I believe it was Judge Sleet who brought up the point about the focus on an insurance bad faith case is on the insurance company, its actions and its inactions. What the claimant thought she would take, less than 200, if anything, whether Ms. Catledge was advising the client, hey, if they come up with 175, maybe you just get this over with because it's going to cost a lot of money to go to court. That is not relevant. It is not appropriate scope of discovery. We would therefore ask that the lower court be quashed.
Very good. Thank you both very much for oral argument. We appreciate it. The next case on the docket, those of you who are paying attention, Johnson versus Progress Residential, it was canceled. It's not on the docket for today. And so we now have the two city family hospitality. We don't have any strict rules about who sits at which table, but you're confusing us.
We had a long discussion. We had a long discussion about that and agreed on many things this morning. One of which is where we would sit. And as a housekeeping matter, I know Your Honor alluded to the two cases being on the docket. We discussed we'd like to handle them together if the court would permit us to each have 25 minutes per side.
So we'll do that. And do you want to reserve some of that time for the wedding?
I would reserve the 5 minutes. I'm assuming that's sort of the max. So I'll reserve the max.
And if you run out of time, they talk about it. If there's on the other side one more time, we could just go on for minutes.
I understand I think we have the rest of the day, right? So. Good morning, Your Honors, and may it please the court. My name is Chance Lyman. I'm here on behalf of the City of Tampa. As we've discussed today, we've got two consolidated cases for the court. And I just want to start by sort of acknowledging it's obviously it's an odd case. I think that goes to say, or it says, we're here on an issue that the parties agreed about below. The circuit court disagreed, generated these 3 appeals, really, which are now 2, 3 appellate proceedings at least. And now we're here on appeal, sort of litigating what I think is a different issue than what was litigated below regarding the statute. So I just think it's important to sort of contextualize what we're going to discuss today. But I think the simplest thing for this court to do is just follow the Florida Supreme Court. And I sort of heard a lot of that discussion going on in the argument we just watched. I think the Florida Supreme Court's already answered everything that is being asked of this court today. And really, there's, I think, two fundamental questions. There's, does the City Council of Tampa have the ability to take quasi-judicial action when that quasi-judicial action is required by the Florida Supreme Court's 1993 Snyder decision? And the second question is, does the Circuit Court have certiorari jurisdiction to review that action? I think the Florida Supreme Court's already answered that, both of those questions. Frankly, I think both of those questions are answered by Snyder. That's where I'm going to start. The other case that answers what the Circuit Court was asking is Locke. That's the constitutional separation of powers. You know, my reading of Liberty's position is I don't think that that's the position they're taking in the appeal. We've already briefed Locke. I'm happy to discuss that if your honors want, but I think my time is better suited to just jump into Snyder.
I think that you all spent a lot of time briefing that issue about the separation of powers and whether it applies to municipalities. And it seemed like it's a complete, really non-issue. You know, it really is whether or not, the city needs to or to distribute quasi-judicial actions. And that's kind of what you said. And that's where I'd like you to start off, and you can start off telling us why the city charter needed to or not needed to say that.
It did not need to. The simplest answer is because the zoning power is a legislative power. When Snyder uses the word power, it uses it one time, and it talks about the zoning power.
Well, but let's stop there. Are we talking about the power, or are we talking about process or procedure? And if it's a power, why do we call it quasi-judicial? Why don't we just call it judicial power?
It's not a power. I think this court's already told us it's not a power in the Verizon case. And that directly applies here, and as this court said in the Verizon case. Although the city council's action on Verizon's application fell into the category commonly referred to as quasi-judicial, this term does not imply that the council possesses quasi-judicial power. Instead, it is simply a characterization of the action itself, one that imposes certain obligations on the city council, and that allows judicial review by way of certiorari proceedings in the circuit court. I think that's the answer to the question that your honor
I
just
think
asked.
we also, though, have the concern that the Constitution makes it very clear that municipalities are not to create any courts or anything of that nature, and courts exercise judicial power. Is that correct?
Absolutely.
Okay, so I take that issue coupled with the fact that we call this quasi-judicial action. So there's constitutionally a prohibition against judicial power being exercised by a municipality. Do you agree with that?
I do.
Okay. So, and when we look at these actions, whether they're legislative activities or judicial activities, it's really the determining factor is what is it the municipal body is doing in that situation. You agree with that?
I do.
Okay. So what's the difference between a legislative action by a municipality and a quasi-judicial action by a municipality?
Snyder has answered that question for us. It's the character of the hearing. And I want to be clear, when I say the character of the hearing, it doesn't mean a hearing where due process protections are afforded. I mean, that's certainly what's going on when quasi-judicial action happens. But this court's decision in CARP, we've cited in our briefing, I think is actually a good example of what Snyder is saying when it's talking about the character of the hearing test. The issue is, as you just said, Judge Morris, what is the local government deciding? Is it formulating a policy or is it applying a policy? That's the line in the sand. And what this court said in CARP was it sort of rejected the argument that, oh, when the Florida Supreme Court said character of the hearing in Snyder, it meant a due process, hearing. That's not what the Supreme Court meant when it said character of the hearing. It said, what is happening at that hearing? What is the decision that's being made? Is it a formulation of a policy, which is going to afford the body's going to have a great amount of deference under the fairly debatable standard? Or is it an application of a policy, which the Supreme Court's telling us in Snyder, no more of that. It quashes a few or it disapproves of a few district courts' decisions that had held otherwise. And it says that's not what what's going to happen here.
But should we be concerned that the city charter distributes executive actions and legislative actions, but says nothing about quasi-judicial actions.
No, for two reasons. One, the constitutional issue that you were alluding to earlier the phrase is quasi judicial power, and the city's position is that is not what happens when a local government who exercises the zoning power with respect to site specific parcels. They are not exercising or attempting to exercise what is constitutionally referred to as quasi judicial power. I think that the simplest answer is the question is whether it's statewide or not. I think
You just said something that I want to follow up on. You said the Constitution, in terms of talking about quasi-judicial. Does the Constitution talk about quasi-judicial?
Article 5, quasi judicial power.
But that's for Article 5 courts and the Article 5 process.
Yes.
And the separation of powers there. But quasi-judicial in the context of this particular charter and Snyder and the other materials that are cited in the briefs, that seems to be a procedural power in order to apply the legislative power of zoning and rezoning. And so if that is not traditionally a judicial power in the sense we think of judicial power, but it is a procedural power, does that make a difference? If you understand that question.
I think it does. Yeah, I think it does make a difference, Your Honor. When we're talking about the judicial power, there's no debate. That's something only an Article 5 court can exercise. And when Article 5, a couple sentences later says commissions and administrative boards may have quasi judicial power, I think the only way to read that is that those are talking about statewide entities. And this is the big line in the sand here for us is we're under Article 8. Everything that we're doing, the local government, everything it's doing with the zoning power.
That's fine. Unless Mr. Altenberg has a different view, I think in his briefing, it appears he agrees Article 5 doesn't control this case. And so under the analysis that the trial court gave seemed to turn almost exclusively on Article 5. And also what she determined was the absence of language in the charter that would authorize this kind of procedure. And yet the charter, and this is quoted in the brief, it talks about section 2.14. It says in the exercise of legislative powers, the council can hold hearings, take evidence, and so forth. And then elsewhere it talks about review of that by certiorari to the circuit court. So I'm not sure if the trial court simply overlooked some of this language or was so reliant on Article 5 that he felt this language doesn't matter.
I think it's the latter. When I read the dismissal order, it's very clearly focused on applying Article 2, separation of powers principles to the city.
Article 2 and reliance on Article 5.
I think those two are connected. It's because again, at least the dichotomy that I'm drawing is it's statewide versus local power. And I think that statewide power is Article 2, Article 3, Article 4, Article 5. Those are irrelevant to this, really, other than that one sentence in Article 5 that tells us not to have municipal courts. And certainly, I don't think there's any argument that local government exercising the zoning.
It's clear from the charter that this is not acting as a municipal court. It is acting as a legislative body who has the authority to take evidence as part of the procedure to decide whether or not to grant rezoning.
Yes, absolutely. And again, I think Snyder just already tells us that that is what's happening. It's this discussion about the zoning authority. They might be taking legislative action, or they might be taking quasi-judicial action. How do we know? We know because the Supreme Court told us to look at the character of the hearing and apply this test to tell us, are they formulating a policy or are they applying the policy? It is always the legislative power with the legislative body that's exercising it. It's always that happening here because the United States Supreme Court and the Florida Supreme Court has told us elsewhere that zoning power is a police power. Police power is a legislative power. Those are the powers. The debate in this case is really one of, what is Snyder saying when they say a local government on a site-specific rezoning request is taking quasi-judicial action? I mean, the Supreme Court just told us what it is. They told us it's quasi judicial action. We determined that it's quasi judicial action. Now, there's obviously an important background to Snyder that has all to do with due process protections and whether, sort of the ballot box is enough to protect an individual property owner's property rights. So Snyder's really fundamentally a due process protection case. What it's telling us, it's telling us we're sort of jettisoning the fairly label standard. It hasn't worked. We've also got the Growth Management Act now that has very much confined a lot of what the sort of, unrestricted zoning power used to be. And of course, it recites all the criticisms that had gone on with the, the use of the zoning power without these restrictions. So the Supreme Court's telling us it's time for a change. It adopts sort of half of what the fifth DCA does in Snyder and says, look, we agree that these things have to be subject to a more strict review in the courts. So the only time that Article 5 is really coming into play in Snyder is what does it mean when it's that certiorari? That's it. And that's the sort of second question I alluded to. I don't think there's any question that the Tampa City Council does take quasi-judicial action. And then Snyder tells us when that happens, the Florida Supreme Court, is telling circuit courts and district courts that the certiorari power that they possess under the Constitution expands to review that specific type of local government action. And I think it's important to note that the Florida Supreme Court, they can tell us what certiorari is and what it isn't. And that's what they did in Snyder. They told us, this is what certiorari is for. We're not going to require that independent action in circuit court under the fairly debatable standard. We are going to say circuit courts and then district courts of appeal exercise your certiorari jurisdiction. I think to pick here to the argument that Liberty's making in the briefing is this discussion of the distribution of powers in the charter, really more specifically in section 166.021.4, right? So we've got sort of the textual argument to that is there is no change that the city is making to its charter that would trigger that statute. There is no distribution of a new power that has happened in Snyder that would require a change to the charter under that statute. On its plain language, this statute just has no application. The statute could have said if a city wants to take any actions. They didn't say actions. And of course they knew, if Snyder's using the word quasi-judicial action over and over again, the Florida Supreme Court is using the term quasi-judicial action in the Florida Rule of Appellate Procedure. There's no appellate procedure rule for quasi-judicial power. It says quasi-judicial action under 9.10. So I think those are all the markers that are coming from the Florida Supreme Court. The other thing I want to say about the 166.021 is this home rule power and this notion of what does it mean when Article 8 tells us except as otherwise by law. Well, very clearly that means there needs to be a specific statute in place that's restricting one of those home rule powers. Again, the Florida Supreme Court already told us that the zoning power is a home rule power. And the only statute that's been, sort of litigated at this point, because the circuit court declined to review statutes, is 166.021. So that's a statute without any plain language hook that could possibly apply to what's going on here. Really, otherwise it's just seems like the question's been answered already in Snyder. I mean, I'll address very briefly the notion that the Hillsborough County Charter, does the right thing. I think that's the main argument I see in the briefing. As we point out, the Hillsborough County Charter does not distribute quasi-judicial power. Again, I don't think any local government charter or constitution can distribute quasi-judicial power because that's something that's going on with Article 5.
Again, I focus on the term that we all use, quasi-judicial, right? Quasi-judicial means not really judicial, but kind of. So if we were talking about judicial power, we wouldn't be saying quasi, right? We would be saying judicial power.
Absolutely.
By virtue of calling it quasi-judicial means we're really not talking about power. Right?
Absolutely. Well, absolutely. I think if the Florida Supreme Court thought it was a quasi-judicial power, they would have told us that, Snyder.
And process versus.
Yes, sure.
Let me ask you a question, because Mr. Offenberg raised it several times in terms of a hybrid session, which he seems to be implying that the city voted down the ordinance, which implies that it either could have been passed through or voted down, which is a legislative act. What do you say that? Because it seems to me he's arguing that this wasn't great out judicial at all. This was a legislative proceeding. We were trying to determine whether an ordinance was going to pass or not.
Well,
Everybody still not.
I've got two responses. I'm not sure that's what Liberty's counsel is saying. I don't think they would take the position that had the rezoning that was at issue in the Liberty's underlying certiorari been granted, that would have been a legislative act, or if it had been denied, that would have been a legislative act.
So you got gas for electric cars. So hybrid means, okay, something other than quasi judicial. What is he saying?
Well, I think what hybrid means is there's a lot of things on the agenda that day, and when we get to this item on the agenda, we're going to be putting on our quasi judicial action hat. And that's sort of what Justice Perriente goes to talk about in the GB case. In her opinion, she tells us, it's very important that the local government, sort of stand up and say, I've now just put on my quasi judicial hat, because it's going to trigger these review mechanisms, the strict scrutiny that Snyder created. So I think that's why, that's the importance of it being a hybrid session. In terms of, it was something that was denied or voted down. I mean, that's still, there's no way to divorce that from Snyder. Snyder is a case that was reviewing the denial of a rezoning application. So, I mean, it's on all fours. Then we know that's exactly what was happening. And what did Snyder say? It said, sometimes that might be legislative, sometimes that might be quasi-judicial. How can we figure that out? Character of the hearing. Once we go through the character of the hearing funnel, we're going to get to certiorari. And that's sort of the segue back to why are we all here today? We're here because a first-tier certiorari petition was dismissed for lack of subject matter jurisdiction. Subject matter jurisdiction for certiorari exists under Article 5, and the Florida Supreme Court tells us when it does and doesn't lie. And they've already answered the question. We have to follow Snyder. And I think the Judge Morris, you've asked many times about judicial power. I think the 6th DCA is that Lightsey opinion that we have discussed a little bit. That's kind of a good example of one of those statewide agencies. It was the Florida Fish and Wildlife Commission. That's a quasi-judicial power sort of commission, when we look at that for Article 5. The Supreme Court has told us a local government takes quasi-judicial action when it applies a policy. It has not told us that a local government is a court when it does that. It has not told us that a local government is exercising Article 5's quasi-judicial power, and it certainly could have. And so I think that's the answer. Of course, we've cited many cases that just follow Snyder and its progeny. And this court, I think just recently, I think Judge Silverman and Judge Sleet, y'all just addressed a Hillsborough County petition just a few months ago. And again, I think follow the rule here, which is that is quasi-judicial action. It is reviewable by certiorari. So I really think it's just an unbroken line. I will note that there is at least one order in the Hillsborough, in the circuit court, that has since sort of conflicted with the trial court's decision. And I just want to note that for the panel's context. But, unless there are any further questions, I mean.
I have one question that actually goes to the second case. The judge in her order concluded that the counts 1 and 2 are factually and legally distinct from count 3. Do you agree with that finding?
I do. I think that voiding the rezonings is absolutely a distinct claim, a distinct, issue in the case. Let me refresh what count 3 is. So count 1 is the Bert Harris, and then and yeah. So I mean, I do think that, the reverse spot zoning. I'm not sure that the reverse spot zoning could be connected to the same thing if the court's really ruling that there was no authority to do, any zoning, really. I mean, I kind of think that's what the court's getting at
This
was,
doesn't seem to be saying they can't do zoning. The court's saying they don't have the authority to conduct a quasi judicial proceeding in order to consider a rezoning application. But it seems to me, at least arguably, that count 2 on the reverse spot and count 1, which is for damages, factually and legally seem to be tied into the issue of, does the council have the authority to take action on zoning issues or rezoning issues? But and then the reason this is important is if they are interrelated in any way, we don't have jurisdiction over the second case or the second order.
well, then let me answer that jurisdictionally and pivot back to our writ proceeding. I think there's no question that this court has either mandamus or certiorari jurisdiction. And if this court exercises those powers, the summary judgment necessarily has to be unwound because it's entirely founded on that issue. So to the extent there's a jurisdictional
Argument by the other side that we should not be considering this as on the first case as a certiorari or mandamus, we should consider it on the second. And I'm troubled by the possibility that we may not yet have jurisdiction over the second until the rest of the case is resolved, which probably could be resolved in light of the fact that she ruled on count 3, but didn't go there.
It did not go there, Your Honor. But I'll say this, that's the adequate remedy argument. I think the only reason that Liberty's contending this court may not have jurisdiction on the first proceeding is the ability to get an adequate remedy elsewhere. I don't think that analysis applies, or that's, I would disagree with that. These are two different cases. If this court doesn't exercise the writ jurisdiction over that dismissal of the first tier certiorari, conceivably, there's no other really way to get at that order. I mean, that was its own separate case. It was its own proceeding. It was certainly, a final order in all other respects. The dismissal order, I haven't seen any cases that tell us that, your adequate remedy is that separate action for, that was in an entirely different case number that precludes you from getting the writ relief that this court has told us, it's not just this court's decision, but the Perry and Terry cases that we cite for our jurisdictional analysis. I mean, absolutely mandamus lies to tell an inferior tribunal that they do or do not have, that they do have subject matter jurisdiction. I think that's the end of it. Think about it this way, I guess, the summary judgment ruling is actually voiding acts of the city of Tampa. That's not at all what happened in the first tier certiorari decision. The first tier certiorari decision could only be a comment on the circuit court's certiorari jurisdiction. And that's the English v. McCrary, line of cases. Anything else in the decision, would be dicta, sort of ironically there. But the comment on certiorari jurisdiction is really something that only exists in Liberty's first tier case, which is why this court does have either mandamus or certiorari jurisdiction to grant relief in that first proceeding.
Very good.
Thank you, Your Honor.
Thank you.
May it please the court, my name is Chris Altenberg. I'm a member of Banker Lopez Gassler. I'm here today with my partner, Eleanor Sills, and together we represent Liberty Hospitality. Let me address a couple of questions first before I get into the main part of this argument. One is the distinctions between quasi this and not quasi this. The truth is that a city is a more unitary structure and it does not have a legislature. But the process of creating ordinances is quasi-legislative. It has an executive that's not quite like the president, but maybe that's closer to the right name. And so that when the charter talks about legislative power, it's really talking about something that's like legislative power. And what I'm taking the position is that likewise should have had a judicial determination after Snyder. But one thing I think we agree on is that Snyder is very important, and why it got decided and how it got decided is very important. We just disagree a lot about that particular problem. The second thing as to the jurisdictional dispositive, I think my side believes that if we prevail on the main issue here, that means this particular application has to go back for a do-over in front of the city council or whoever it is that conducts the quasi judicial aspect of this. And that may
The problem with that is the city charter doesn't provide for that, does it?
a do-over.
A do-over in front of a magistrate or a hearing officer for this context, because it seems, and it's again quoted in the briefing, that the charter says in section 214, here's what the city council does in exercising its legislative powers. It can hold hearings and call witnesses, compel the attendance of witnesses, and so forth. So what authority would there be for a do-over in front of somebody else?
Well, there wouldn't be authority for a do-over in front of anybody, frankly, until they fix their charter. And it's unfortunate that they haven't started that during this process. But if the trial court is correct, and by the end of this oral argument, I hope I can explain to you that despite the long order, I think she's absolutely right, that they do need to have that process resolved. And when that's done, the application, if it's defective for these reasons, we'll have to start over again. And the only reason I say that is we think it probably makes the Bert Harris and the reverse spot moot at that point in time. So that's why I think it's a separate, distinct issue that you could resolve.
But aren't they factually and legally related, even though it may be mooted by, if we were to, what trial court did, and send it back for a do-over? If we didn't send it back, if we didn't agree with you, how are they not factually and legally interrelated? The remedies may be different.
There won't be reverse, well, I'm not real comfortable telling you what reverse spot is, but I don't think it exists unless this thing is in place. But I'm confident there's no Bert Harris taking until there is actually an ordinance that's done something. So I think those two are mutually exclusive on this. So I do think that the appeal is your better vehicle, but one way or the other, you can answer the questions that are here.
Well, to go back to what you started out with, in terms of quasi-legislative, quasi-judicial, quasi-executive, doesn't that undermine the idea that a city council cannot do what its charter expressly authorizes? If it's not exercising a judicial power, but is simply a quasi-judicial power, which is a procedural issue, why is that now turned into, well, it's acting like a court?
Because I don't believe it is a procedural issue absent power. And let me try to explain this now by going through Snyder, what it did, and what is misunderstood about certiorari in the city's argument, that frankly, this whole concept that, well, it's just a component of making a zoning ordinance. And because it's just this component, they can do it without going back to the people and finding out who should have the power to do what they admit is a due process hearing at the front end of this, protect the private property rights of the person submitting the application for parcel specific zoning or
So
spots.
let me ask a discrete question on that.
Yes,
Haven't the people already spoken by virtue of what's in the charter?
no,
Why not?
because there's been no authorization in there to hold a quasi judicial hearing to protect the private property rights of the citizen who files this application.
And why does section 2.14 not accomplish exactly that?
Because section 2.14 has a sentence at the end, right? Is that what you're relying upon? And the sentence at the end says that any power except the purely legislative power authorized or required by general law, which doesn't quite apply here, shall be exercised by the city council upon recommendation or with the approval of the mayor. I'll start off with, by the way, after Snyder, they didn't sit down, they got no evidence, they sat down and got a recommendation or approval of the mayor. But what's far more important is that this was in there when section 166.0214 had its language in it. And we know that after Fleetwood, the legislature came back and said, no, we really mean home rule. And the cities are going to be doing all of these things, but there's one thing we want to override. It says, nothing in this act shall be construed to permit any changes in municipal charters which affect which affect the distribution of powers among elected officers without approval by referendum of the electors as provided by in section 166.3031. That's very clear language. You can't do something about the distribution of powers of elected officers unless you go back to the voters. So you can't put into your charter at the time this was put in, something that says, well, if we need to distribute a new power, we all just going to sit around, us and the mayor, and we're going to decide who gets to do it.
So, Mr. Altmer, how would you amend the city charter? What should it have said?
It needs something in the separation of powers clause and maybe somewhere else that adds a discussion.
But the Constitution doesn't allow a municipality to exercise judicial power.
So that's why I want to talk about Snyder, okay? Can you give me 5 minutes to talk about Snyder? Because it doesn't allow them to do Article 5 power. And what Justice Grimes was carefully doing in Snyder, because I think he understood this problem, was finding a way to make it a judicial tribunal for the first half of this that determines the private property rights of the citizen involved in this, the due process matter, before they then go on to discuss whether the community issues and whatnot are sufficient that they can create the ordinance. He divided it in half, and he divided it in half because of certiorari. So this is where, respectfully, the trial judge in this case got separation of powers absolutely correct. She's focusing at least a good part in her one long order on her powers as a circuit court judge and her powers as a circuit court judge using certiorari. And she has figured out the same thing I submit to you that Justice Grimes figured out when he sat down to write the decision in Snyder. And that is that certiorari from its earliest beginnings, it's a common law proceeding involving a power of a higher court to reach down and correct an error departing from the essential requirements of the law of a lower court. The courts under common law inherently have the power to police themselves. They don't have the power to police the legislation or the executive branches of government. Civil actions can be filed to challenge the constitutionality of that, and they can invalidate things in that fashion. But to use certiorari, the body they're reviewing has to be a lower tribunal that's warranted and has enough power to do a judicial act. That was the problem that confronted Justice Grimes when he came to write Snyder. The background of Snyder is a little important, and I'll spend a couple minutes in the weeds. If you don't.
I want to interrupt at this point because in looking at what Justice Grimes wrote, he talks about the legislative analysis as to whether the board's action on the rezoning application was legislative or quasi-judicial.
Mhm.
And then goes further and says, on the other hand, the rulings of a board acting in its quasi-judicial capacity are subject to review by certiorari. And then in the next section talks about enactments of original zoning ordinances have always been considered legislative. And then he emphasizes later, it's the character of the hearing that determines whether or not board action is legislative or quasi-judicial. So I'm not quite sure when you say he was being very careful in separating out what you suggest supports the judge's order. I don't see that.
Okay, let me try to explain. Because he uses the word character. And part of the reason is he's actually probably trying to avoid being too critical of the 5th District and some issues that arose before this. Because they have this long debate about whether they should use the fairly debatable standard or whether they should move to a quasi-judicial hearing. And it's true that not only they, but there's a handful of prior certiorari proceedings that use fairly debatable. Justice Grimes was an exceptional justice. And I know.
Listen, I don't think he really minded criticizing any court.
Well, there was a decorum to him. So one way or the other, fairly debatable has been used for 100 years and often in civil court and civil proceedings to challenge the legality, the constitutionality of the passage of an ordinance or passage of something in the legislature sometimes. It's a challenge to the police powers of the ordinance itself. It's a power that the courts have to address legislation. It's not a power that they can use in cert because they have to have a lower tribunal doing the business of a lower tribunal. And so he just skipped that whole discussion and jumped right to, I'm going to create a quasi-judicial hearing that is sufficient to make it a judicial tribunal so we can give it certiorari review. So what did he do? Not only does he talk about strict scrutiny when he means less than equal protection there, but he said he created a burden of proof on both parties. They have to present sworn evidence from witnesses. They have to have documents, and they have to announce an outcome about the hearing that's designed to protect the private property rights of the citizen before they go on to decide whether they can pass an ordinance that will be applicable and impact the people that are in the surrounding properties. Now, what is reviewable in the cert? It is not the ordinance. They can't get to the ordinance. Only thing they can review is the judicial proceeding that precedes the creation of the ordinance. Constitutionally and under the common law, that's all they can do. And that was known by the whole court when they did this. So they created a form of a tribunal. And how is it reviewed under the strict scrutiny? You review the entire record of evidence for what? Competent, substantial evidence. That sounds like reviewing a trial court that's trying a case non-jury. Was there competent, substantial evidence to report to do what the judge did? So what they did in this case was they created a vehicle to protect the private person. And that vehicle is very much judicial. I'll get to a moment between how to separate that from Article 5 and what they've done here. But it is enough to make it judicial for certiorari, and that's what the lower court in this case understood. Now, he correctly points out that they did that because of changes in the law that developing land development codes. But the truth is, and it was well known at the time, that by using the fairly debatable standard over the years, we had created a culture practically in Florida where county commissions and city councils were deciding the rights of private property owners in spot zoning in a fashion that was either political or flat out bribery. The poster children of that were from here in Hillsborough County. There were 2 commissioners who were arrested, tried, convicted, and sent to prison because of bribery in cases just like this one. And they did it because they could do it under fundamental fairness. Those people, by the way, were
But
booked.
those issues are not in play here, so.
No, they're not in play.
Why this is relevant.
Okay, it's important because there was very much a need to get to a hearing that was quasi-judicial. And that's what they were doing, and there was a need to have it reviewed by a court because otherwise, as a legislative process, it went back to fairly debatable, and let's go zoning could come right back to Hillsborough County. That's why they were doing this.
So in our case,
Yes.
Verizon versus Sanctuary, one of our cases, 2005, we write quasi-judicial does not imply the council possesses judicial power. Instead, it's simply a characterization of the action itself, one that imposes certain obligations on the city council and that allows judicial review by way of cert proceedings in circuit court. We were correct, right, in that decision?
The decision was correct. And in the context that Judge Northcutt was using the words power there, I think he was correct. But what he's talking about, if you read the whole opinion, is the power of an Article 5 court. What had happened there was that the quasi judicial body had decided that it could declare, as I recall, an ordinance or a piece of legislation invalid. And they had also decided that they could apply equitable estoppel as a quasi judicial tribunal. And what this court held was they did not have the power to do what an Article 5 court could do. They could only have the power to do what a quasi judicial hearing was supposed to do. Well, that did not include these things.
Perhaps the way I read that is he is defining the quasi judicial does not imply power. It implies process.
He just left out the power of an Article 5 court. Respectfully, the problem here is that no one was briefing to the Supreme Court in Snyder, well, if you do this, then county commissions and city councils might have to change their charters. We know that wasn't briefed, it wasn't argued, it wasn't discussed. To the best of my knowledge, the first lawyer judge who ever asked the question, by what authority are you conducting a quasi judicial hearing? If you are a charter city with a strong mayor, city council, and a system that has a separation of powers clause, which is a narrower body of municipality, by what authority are you doing this? First time anybody in Florida asked that was in this case. It was not answered in any of those cases. It certainly wasn't answered in Kahuna, which was just about sending it back to make the judge figure out whether he was actually in a spot where it had been legislative or quasi-judicial. So this case, quite legitimately, is a question of first impression that at least impacts other communities with a very similar charter situation. It's not going to affect smaller towns that have a single, they give all the powers to the city council and select a mayor from the city council. I don't think this affects those people. But it does affect this, and there's no way we can honestly say that there's anything but dicta in any case that precedes this. So now the question is, when you go to their other arguments, trying to distinguish why this is a tribunal so that we can review these by cert. It's not an Article 5 court. Okay? That argument's correct. But when we put into Article 5, Section 1, the notion that boards and commissions could have quasi-judicial powers, the one thing we were recognizing was that a quasi-judicial hearing does involve power. When the voters voted to do that and add it to the Constitution, we don't have to go back 200 years for original intent, 1973. We understand that quasi-judicial is a power. Now, Article 5 does not give a municipality that power. But what I think I agree with the city on is that Article 8 gives all government powers to whom? To the municipality. So yes, they can have quasi-judicial hearings as a power because they have all government powers given to them under home rule to the city. The problem is that none of that decides who is going to exercise that power. And when this charter was enacted in 1975, we had just eliminated, as you know, the municipal courts. I guess they just came to the conclusion we got no judicial powers to worry about, so there was no discussion of that. But that does not mean that, oops, because we forgot about it then, or because it was changed by the Supreme Court in Snyder to salvage the ability to have cert review of the part that protects individual private property owners' due process rights. To save that, they have to have power as a tribunal. And the only way they can get that under section 6.0214 is to let the people decide that. It's a home rule by the people. You know, I agree that there's the separation of powers clause of the state of Florida doesn't apply here, neither does that one in the U.S. Supreme Court. But all of this goes back all the way to Montesquieu in 1740, and the notion that the liberty of the people is best protected by a three-party system. Not every city has done that in their charter, but Tampa did. And I'm not telling you that's a bad idea, but it's been a good idea for hundreds of years. And having chosen by the people in this town to have that as their charter controlling decisions, they have the right after Snyder to decide who was going to make them. It's not just, it's an oh, by the way thing we do, and then we pass an ordinance, and we'll take the ordinance up to the circuit court and see whether they like it. That's not what the Supreme Court was doing in Snyder. They were intentionally creating a system to get away from fairly debatable and into a process where they could review it by search warrant. And frankly, that was a very wise thing for them to do, and we should not go back to any other system other than that. So the problem is that they probably need to fix it. Maybe some other cities do. I don't think people will go back very far on things that have already been done. But as to these people, this circuit court judge was right that the separation of powers kept her from looking at a proceeding that was performed by someone that was not a legitimate source of authority to conduct a quasi-judicial hearing. That's what this is about. And I will sit down unless you have some questions.
Very good. Thank you.
Thank you.
Thank you, Your Honor. I'll go briefly through a few points. Judge Silverman, you were talking about 2.14 in the charter, and that is different from the 1.04 provision, and you're absolutely right. 2.14 it gives the city council the ability to conduct that hearing. That's a hearing power. I think I want to spend the rest of my time just talking about the point of certiorari. Again, I sort of opened with this, and I'm going to stick with it. The Florida Supreme Court can tell us what certiorari is and isn't. And they told us what it is in Snyder and where it lies. And I think that this court would have to follow that. I don't think that there's a way to read what Snyder does as anything other than instruction by the Florida Supreme Court as to what certiorari jurisdiction is. And I'm not sure that, we can go back and say, well, they got it wrong in Snyder. I don't think we can do that today. Second, certiorari as a common law, as a king's writ, it absolutely was the vehicle by which you examine the record of the proceedings. So it, I think, fits perfectly in what Justice Grimes was trying to accomplish in Snyder. It's not a review of the ordinance, it is a review of the record, and it's a review for regularity. I mean, that fits the common law definition of certiorari. And third, the lower tribunal does have a definition in the appellate rules, and it does include what the city council is. The definition right now in 9.020 is the court, agency, officer, board, commission, judge of compensation claims, or body, I think that's the council, whose order is to be reviewed. I think that's a lower tribunal. I think the Florida Supreme Court has the authority to define the lower tribunal that way in their rulemaking authority. It's the same authority they have to define certiorari. And just to turn to Verizon very quickly, the city council and Verizon, they were not exercising judicial power. They weren't the ones who wanted to avoid the telecommunications ordinance. I think they followed, what they were supposed to do, and it was the circuit court's review where that sort of got a little bit off track, which is why this court had second-tier certiorari jurisdiction over what happened in Verizon. So I do certainly think that Judge Northcutt's analysis is spot on and binding on the issues that have been presented today. If there are any further questions, I'm happy to answer them. Otherwise, we'll rest on the briefing.
Very good. Thank you. Look, we do not get very many of these cases, so we appreciate the good briefing and the good arguments. So thank you. That concludes the oral argument portion of the docket. We are adjourned.
All rise. Thank you. Travel safely.
I know. Just feel it. Get a child. On the bill. And you still not. Oh, I know, what you, I remember. That's nice, I remember that, I should be saying. Yes, she did a lot of it, I used to say all that.